Good evening, friends. I am delighted to be here discussing something which is very close to my heart. In the recent past, probably I started practice sometime in 97, 98. I don't remember having come across such a controversy, which is not dying at all. It is going on. And every time we believe that the controversy is going to be settled now by the court, once again it rises out of the ashes, as in the phoenix bird. This time around also, we all thought that matter would now be decided by the Supreme Court and it will rest over here. But after going through the judgment and after analyzing the law on the issue, probably I believe that we are going in for another round of litigation. With this, friends, today's topic is the limitation aspect, which is arising because of the introduction of TOLA and thereafter subsequent amendment into the Income Tax Act. And as a result, large number of reopenings have taken place. The short issue is that whether those reopenings are within the limitation period or beyond the limitation period. But then only the issue is short. The discussion is going to be a lengthy one. Let me give you the background, because unless we understand the history, we would not be in a position to appreciate what is laid down by the Supreme Court. Friends, in a simple language, we all know that we all suffered because of TOLA, because of the COVID. COVID affected the world at large, and there were almost large number of countries which came to a complete standstill. And that is the reason why government across the globe decided that we need to freeze the time for compliances. We need to freeze the time for initiation of certain actions by the revenue authorities. We need to freeze the time so that assessees can do the filing, etc., at a later stage. And that is the reason why right from 20th March 2020, we had something known as TOLA, that is Taxation and Other Laws Ordinance, which came at a later date. However, what it did was that the time which was flowing from 20th March 2020 was stopped in terms of all kinds of compliances. The time was stopped. And the dates which were falling after 20th March 2020 got extended right up to 31st March 2021. In between, TOLA, that is Taxation and Other Laws Ordinance, became TOLA Act. And by virtue of TOLA, again, the extension, etc., it got a statutory color. So the issue is that from 20th March 2020 right up to 31st March 2021, there was an extension in as much as whatever compliances by both revenue as well as the assessee, whatever was required to be done could be done by enjoying certain extensions. TOLA also had a power to extend beyond 31st March 2021, and by virtue of exercise of that power which was flowing from TOLA, government issued two notifications and extended the due date further up to 30th June 2021. One of the issues because of this extension was the issuance of notice under Section 148. So therefore, as per the prevailing Income Tax Act, as it was then during 2020, there were two broad deadlines. One was an assessment up to a period of 4 years, wherein, except for escapement and reason to believe, there were not much conditions. And anything beyond 4 years, up to 6 years, there were a few conditions. However, there were two limitations which were there, 4 years and 6 years. And therefore, between 20th March 2020 and 31st March 21, the reopening period for assessment year 13-14 and 14-15 got expired. Because as per the prevailing law then, 13-14 had an outer limit of reopening up to a period of 6 years. And 6 years from the end of the year, 13-14, end of the year is 31st March 2014. If I add 6 years to that, I'll get 31st March 2020. Likewise, 14-15, if I add 6 years to 31st March 15, I'll get 31st March 2021. So on both these dates, 31st March 2020 and 31st March 2021, the 6 years period was getting expired. So TOLA said that, sir, if this 6 years are getting expired on the respective dates, we will extend it by virtue of TOLA up to 31st March 2021 and by way of 2 additional notifications up to a period of 30th June 2021. Now, so far so good, no problems. The problem arose because in between, the law has undergone a change. With effect from 1st April 2021, Parliament came out with a different law. I'm not going into the nitty-gritties of that new act. I'm only going to the limitation aspect prescribed under the new act. The new act stated under section 149 that now we have 2 slabs of reopening. One is reopening up to a period of 3 years. Again, no material conditions. Any reopening beyond a period of 3 years up to a period of 10 years, then there are conditions which are embedded therein. Along with that, there was a proviso to section 149, wherein in no uncertain terms, Parliament said that the limitation under the old scheme, with whatever limitations under the old schemes which are over, would not get revived under the new scheme. In other words, the years which have become time barred under the old scheme, under the old limitation, 4 years and 6 years, which I just explained, they would not get revived and they will not get any additional life. The simple reason is under the new scheme is between 21 and 24, because after 24, again, we have another new scheme. Therefore, whenever I refer to, for this lecture's purpose, whenever I refer to new scheme is the scheme which was prevalent during 2021 to 2024. When I say old scheme, the law prior to 1st April 2021. Under the new scheme, we have a larger limitation period, namely a period up to 10 years. And therefore, under the old scheme, where the limitation outer limit was 6 years, there was a case where limitation can go up to 16 years. However, we are not concerned with that larger limitation for the time being. And therefore, I am not troubling you with that. Therefore, the 6 years and 10 years, the additional 4 years, those additional 4 years were the subject matter of the first proviso. What the first proviso said was that something which has become time barred under the old regime, under the old scheme, you can't revive them because now you have a larger limitation period. And therefore, the proviso was inserted to preserve the vested right which has accrued in favor of an assessee, that his assessment became time barred, and that assessment, because it has become time barred, would now not be reopened under the new act. So we are concerned, frankly, more with 13-14 and 14-15. Just to carry forward that example, that 13-14, 6 years got over on 31st March 20. By virtue of TOLA, it got extended to 31st March 2021. By notification, it got extended up to 30th June 2021. Now, with effect from 1st April 2021, the law says that whatever has become time barred, that would remain time barred and it will not get revived under the new scheme, merely because we have a larger limitation period. For 14-15, again, 6 years got over on 31st March 2021, and therefore with effect from 1st April, it would have otherwise become time barred. However, TOLA notification said up to 30th June 2021. Therefore, it got extended to 30th June 2021. Taking a clue from this, revenue authorities started issuing notices between the period 1st April 2021 and 30th June 2021. Initially, under the belief that because of TOLA read with the notifications, we have time to issue notices right up to 2021, 30th June. And therefore, they have issued large number of notices between this first quarter of financial year 21, between 1st April to 30th June 2021. All those notices were challenged by the assessees on the ground that these are the notices which are issued under the old scheme. However, we are under the new scheme when there is a parliament which has consciously passed an enactment tweaking, changing the limitation period. There is no question of now allowing the revenue authorities to continue to issue the notices under the old scheme. Effectively, what was happening was that from 1st April 2021 to 30th June 2021, there were two schemes in operation. One was the old scheme as extended by the notification according to the revenue, and another was as introduced by the parliament with effect from 1st April 2021. Therefore, the notices were challenged across the country, and almost all the high courts were of the view that yes, Parliament's intention is supreme. Once Parliament has enacted a new law, then you can't continue to issue notices under the old act. And therefore, all those notices which were issued under the old scheme between 1st April to 30th June 2021 were declared as invalid and without jurisdiction. Revenue against all these matters preferred SLP, which was later on decided by the Supreme Court in the case of Ashish Agarwal. In the case of Ashish Agarwal, the judgment was delivered by the Honorable Supreme Court on the ground that there was a consensus between the Assessees Council and the Revenues Councils that all these notices, though issued under the old scheme, can be treated as a notices having been issued under the new scheme. However, it would go back to the show cause notice stage. All of you are aware that under the new scheme, 148 capital A have four clauses A, B, C, and D. A was preliminary inquiries, B was the show cause notice, C was the reply stage, and small d was the order stage. So there were four stages which were defined under the new scheme under section 148 capital A. So Supreme Court decided that we will treat all these notices, though issued under the old scheme, under a mistaken belief by the revenue authorities. However, looking to the large number, namely around 90,000 matters, and looking to the stake involved, we believe that this was a genuine error on the part of the revenue authorities, and therefore we want to give them one more opportunity by invoking Article 142 of the Constitution of India. And therefore they converted all those notices which were issued under the old scheme as notices having been issued under the new scheme at the show cause notice stage. Kindly mark this because I'll come back to this sometime later during the presentation. It was treated as a show cause notice. Supreme Court also, in the very same judgment of Ashish Agarwal, noted that we are keeping all the defenses of the assessees open, including defense of limitation, because large number of assessees felt that all these notices, even issued under the new scheme, have become time barred. And that is how the matters got disposed of in Ashish Agarwal. Matters were sent back to the file of the assessing officer with a direction that you treat all these notices as a show cause notice under 148 AB. Now you give the material which you have used for the purpose of issuing the show cause notices and elicit response from the assessees by giving them 2 weeks time and any additional time if at all they are asking for it. And thereafter, once they file the response to this show cause notice, you pass an order under 148A small d into bracket, and thereafter issue the notice if at all it is permissible under section 148 of the Act. In the second round of litigation, when the matters were sent back, again the issue as regards the interpretation of first proviso to 149 cropped up. because Supreme Court said that we are keeping all the issues, including issue of limitation, open. And therefore, broadly in the second round, the arguments of the assessees were that, sir, 13, 14, 14, 15, the matters have become time barred on 31st March 2021. Because the matters have become time barred on 31st March 2021, you cannot thereafter invoke the extended limitation, and therefore your notices have become time barred if we read first proviso to section 149 minutely. The reliance on the first proviso to 149 was to the effect that the matters which could not have been issued under the old regime now cannot be issued under the new regime. And therefore the argument was that since the 6 years are already over, and therefore the question of extending any further by virtue of those notifications, because notifications were contrary to the law which was laid down by the parliament, you could not have issued those notices because those notices have become time barred on 31st March 2021. It was also argued that, sir, you cannot extend the law which has already been repealed, and large number of other arguments to the effect broadly that once the parliament has enacted a new law, and that new law has with a specific object in mind, namely certainty, has been enacted so as to avoid this old reopening, you have to respect the decision of the parliament, and you can't thereafter reopen 13, 14 and 14, 15. Once again, all the high courts across the country almost decided the issue in favor of the assessee by holding that yes, for 13, 14 and 14, 15, because the 6 years outer limit is there under old 149(1) small b, the matters have become time barred, and therefore the entire issue is without jurisdiction. All the notices were dismissed. Simultaneously, as regards 16, 17 and 17, 18 also, there was one more issue of sanction, which I'll deal with when I go to the sanction part of it. Let me concentrate as of now only on the limitation aspect for 13, 14, 14, 15, so as to make it simpler at this stage. Again, revenue authorities approached the Supreme Court, and their argument broadly was that, sir, we are right, we have the jurisdiction. TOLA has to be read into the first proviso to 149. And therefore, once you read TOLA along with the proviso, we get extension up to 30th June 2021. And because all these notices were issued within that extended period, we have jurisdiction to issue. Broadly, this was the issue which was raised in Rajiv Bansil's case. And thereafter, Supreme Court has recently delivered the judgment in the case of Rajiv Bansal and decided the issue once again. Broadly, in normal terms, against the assessee in favor of the revenue. However, if we read between the lines, then probably we can find some silver lining to the judgment, and we can find some defenses which are still open to the assessee, and we can accordingly plead our cases in the probably unwanted third round of litigation. Let us see what the judgment has decided for 13, 14 and 14, 15. You look at the judgment, you realize that it was a judgment which was argued for all the years together. Because it was a judgment which was argued for all the years together, it is difficult to decipher and find out the exact relevant parts which are applicable to various years, because the judgment is decided insofar as the issues are concerned and not in terms of the assessment years. And therefore, we have to look at the judgment per se from the point of view of only 13, 14 and 14, 15. You would find judgment is summarized from paragraph 53 onwards. So if you look at paragraph 53 of the judgment in question, that is Rajiv Bansil's judgment, you would find that court has discussed the entire issue in a under various heads. Let us look at the limitation aspect first. That what is it that has been done for 13, 14 and 14, 15? Court has held in paragraph 105 that if we are reading the first proviso to 149(1)(b), one would find that the proviso says that whenever there is The first proviso to section 149, let me just hurriedly point out what is first proviso to 149. First proviso to 149 is basically a savings clause whereby the limitation which has expired under the old regime were continued under the new regime as well. And therefore, those rights, the vested rights of expiry of limitation against a particular assessee was preserved in the new act. Now, the proviso very categorically refers only to the old act, namely the limitation as prescribed under section 149 1B of the old act. Only that limitation was touched upon, and that 149 1B of the old act talks about 6 years. Now that limitation was preserved under the new scheme, and therefore the broad argument of the SSC, which is now rejected by the Supreme Court, is that sir, when you read the first proviso says that you have to look at the limitation as prescribed under 149 1B. Now 149 1B talks about outer limit of 6 years. 149 1B does not have any amendment which is induced by TOLA. Neither the first proviso under the new act refers to the limitation under 149 1B read with TOLA. And therefore, the extension which was granted by virtue of TOLA cannot be read under section 149 1B of the old act. Because you can't read this extension, there is no question of going beyond a period of 6 years. And that is the reason why the Parliament, in its own wisdom, has only made a reference to 149 1B of the old act and has not mentioned TOLA, though TOLA act was very much in existence and Parliament itself passed it sometime earlier. However, Parliament has not referred to TOLA while dealing with 149 1B. If that be the situation, while reading first proviso, can we read the extension granted by TOLA? Supreme Court said that yes, you can read, because whenever you are reading the old act has to be necessarily read with the extension granted by TOLA. You cannot read the old act in isolation and forget about the extension. Extension is granted to the specified act, and specified act covers the Income Tax Act. And therefore, when one talks about the extension of limitation as flowing from the specified act, you can't read only the act, namely the Income Tax Act, and detach the TOLA. Therefore, TOLA extension has to be read whenever you are reading the old act. You have to read it along with TOLA extension. And therefore, to that extent, court has said that even if there is no mention of any TOLA reference, etc., in the first proviso to 149 under the new act, and even if there is no amendment per se under the old act, extension of limitation which was prescribed under TOLA, you have to read that 6 years limitation plus 3 months which is granted by TOLA. So the first part was decided against the assessee. Then Supreme Court went on to further say that assuming that Parliament is correct and 149 first proviso under the new act does not have any reference to the old extension, etc., granted under the old act, and if in case, even if there is any apparent conflict between the first proviso to 149 and the extension granted under the TOLA Act, then the TOLA Act shall prevail, because TOLA is a specified act. The intentions of TOLA was to grant extension. And when we are interpreting more particularly the language of section 3 of TOLA Act, which starts with a non-obstante clause, namely notwithstanding anything contained in any other act and anything contrary, TOLA shall prevail. Therefore, the Supreme Court said that TOLA will have an overriding effect over the Income Tax Act, even if assuming there is some conflict between the two. That said, 13, 14, 14, 15, Supreme Court said that now that we are seized of the matter, you have to read limitation up to 30th June 2021 when you are applying the old provision. Therefore, when we read first proviso to 149 under the new act, the reference to 149 1B under the old act has to be read by adding 3 months to that limitation period. Once I take that into consideration, admittedly all the notices are issued between 1st April and 30th June 2021, which was within the extended period of limitation. And therefore, Supreme Court said that these notices are valid notices. And therefore, they are rightly converted by Ashish Agarwal into the show cause notice 148 capital A small b. Therefore, up to that stage, there is no dispute as regards any limitation. Even now, the assessees have to accept that yes, notices are validly issued and they are at a show cause notice stage between the 1st April and 30th June, depending upon the date on which you would have received your respective notices. You means your assessees. Now comes the second stage. Supreme Court said that Ashish Agarwal has put the clock back to the stage of show cause notice. Thereafter, Ashish Agarwal held that two things are required to be done by the assessing officer. One, 148 AB notices are required to be issued. And second, you have to supply the materials which was relied upon by the assessing officer in favor of the assessee so that assessees can deal with that. Ashish Agarwal also held that for the purpose of this reply, 2 weeks time may be granted. And in case if someone wants more time, then that time, extended time can also be granted because 148 capital S small b provides for extension of time. Once the reply is received, then you pass the final order and follow the procedure as per the law. Supreme Court has broadly upheld that aspect of the matter. Now comes the interesting part. Supreme Court said that yes, we extend the limitation up to 30th June 2021 for 13, 14, 14, 15. We go back to the show cause notice stage. Once we go back to the show cause notice stage, then again we go by the new scheme of the act, namely 148 capital S small b. 148 capital S small b says that 2 weeks time to be granted as per Ashish Agarwal, granted. And whenever the response is received, assuming for the purpose of this discussion that the notices are received back within a period of 2 weeks, then my limitation would start running from that date. That is the date on which the revenue authorities are expected to thereafter carry out the formalities of A, passing the order under section 148 capital S small d, D as in Delhi. And thereafter, issuance of notice under section 148, because that is the last stage which is contemplated under the new scheme. Now, both these items, namely both these tasks, are required to be carried out within the remaining permissible time. Now, what is that remaining permissible time? Supreme Court said that, look, sir, we have already extended the limitation up to 30th June 2021, no dispute. From 30th June 2021, we believe that we have to reduce in paragraph probably 94. Supreme Court has summarized this, that from 1st July 21 to 3rd May 2022, by virtue of Ashish Agarwal, the limitation will get excluded. Therefore, that period is required to be excluded up to 1st July 21 to 3rd May 2022. That period is required to be excluded. From after 4th May 2022, when the Ashish Agarwal was delivered, you have to go to the issuance of actual notice under 148 AB, read with all the materials which is supplied to you, because that is the time which is taken by the revenue authorities for the purpose of issuing all these notices. Thereafter, by virtue of the third proviso, as it then was, to 149, the time which is given to an assessee for the purpose of responding to notice under section 148 AB is required to be excluded. Therefore, Supreme Court has reproduced the third proviso, and they said that this time is required to be excluded from the limitation period. And in the remaining time, the revenue authorities have to justify, have to fall within the limitation period, counting from the day on which the judgment of the Ashish Agarwal is delivered. In other words, let me put it in a slightly simpler terms. Supposing the authorities have got an extension of 90 days broadly, counting from 1st April to 30th June, authorities have got an extension of, to be precise, April, May and June, 91 days extension is given to the authorities. Therefore, they are required to carry out all the tasks and reach to the final notice stage within a period of these 91 days. out of 91 days, whatever days are taken for the purpose of issuance of the first notice, those days are required to be excluded. So supposing in somebody's case, the notice is issued on 20th of June, 20 June, then the assessing authority will have only 10 days time to carry out all the formalities post Ashish Agarwal's judgment. And therefore, if I exclude all the permissible exclusions, the task is required to be carried out in the remaining surviving days. I have prepared a small table just to put across this point. I'll share it on the screen. In this case, I have taken an example of notice having been issued on 25th June 2021. June 25th June 2021, the original notice was issued, and therefore only 6 days were remaining. Kindly mark this, because again, at the relevant point in time, we'll have to take into consideration even the fourth proviso to 149, which says that if less than 7 days, then it is automatically extended up to a period of 7 days. Here is a case where 25th June, therefore less than 7 days, therefore by virtue of fourth proviso, it will be extended to minimum 7 days remaining time. In this case, 25th June 21, the original notice was issued. On 4th May, Ashish Agarwal got delivered. On 25th May, I received a show cause notice under 148 AB asking me to file my response by 16th June 2022. I furnished my response on 14th June 2022. The authorities issued notice under clause D on 31st August 2022 and final 148 on the very same day, 31st August 2022. Therefore, as per the Supreme Court guidelines, the limitation stopped on 25th June 2021. My time which was allowed to me was up to 16th June. Therefore, up to 16th June 2022, the clock has remained stopped. If you read paragraph 94 of the Supreme Court judgment, probably you will realize that right up to that date, namely the day on which I have to file my response under clause small b, B as in Bombay, the clock will stop. Once I file my response under small b, again the clock will start, and assessing officer in my case would have only got 6 days time, because 25th to 30th June, 5 days time, and therefore he would get, by virtue of fifth proviso, get an extended time of up to 7 days to finish his remaining task. In my case, because the notice is issued on 31st August 2022, therefore, the notice is barred by limitation, even after the Supreme Court judgment in Rajiv Agarwal's case, Rajiv Bansil's case. Therefore, in each and every case of 1314 and 1415, what one has to do is one has to find out what is the date of actual issuance of notice, and thereafter go right up to the day on which you filed your response in the second round in response to notice under 148 AB. Once that date is determined, whatever remaining period is available, that period has to be equated with the remaining period from the day of issuance of original notice up to 30th June 2021 is required to be compared. If assessing officer has taken more time as regards the time which was available, the notices are all time barred, and you can once again argue that your notice, even as per Supreme Court judgment, is barred by limitation because AO has taken more time. If you look at it broadly, just to give a broad picture, by and large, almost all the responses by the assessees post Ashish Agarwal got filed in the month of June itself. So if you remove June, then, and most of the notices are issued in the last week of July or first week of August. So revenue authorities, by and large, took 60 days time to process the responses. And if at all your notice is issued in the month of later half of May or in the month of June 2021, most probably your matter would be barred by limitation and you can get away from 1314 and 1415. That would take me to the next interesting assessment here, that is 1516. Because a lot has already been said about 1516. What is the effect of 1516? 1516 again is an interesting issue. If you look at paragraph 52 of the judgment, you would find that there is a concession given by the learned ASG. If you look at the concession, that concession is without any specific reference to any assessment year in paragraph 52. He says that wherever the 6 years period is not over, then TOLA cannot be pressed into services and all those notices will go. He, however, on paragraph 19 of the judgment gives a categorical submission on behalf of the revenue. Immediately after the chart, you will find paragraph F, part of paragraph 19 of the argument of the revenue, that assessment year 1516, all the notices which are issued post 1st April 2021 will go. And he has made this unqualified statement, which has been accepted by the Supreme Court, and therefore you will not find any discussion for 1516, because for the simple reason that revenue conceded to this position that 1516 is outside the purview. Why 1516 is outside the purview? For the simple reason that 1516, the limitation would have expired on 31st March 2022, because I'll have to add 6 years to 31st March 16. Now, March 22 was not falling within the period when TOLA was applicable, namely 20th March to 31st March 2021. Therefore, there is no question of extending the limitation. Once there is no question of extension of any limitation, therefore TOLA will have no application. Supreme Court's judgment, right from paragraph 54, 62 and 63, 65 to 68 and 71 and 72, the combined reading of all this paragraph would leave no doubt in my mind that what Supreme Court meant was that what is extended is what is getting expired during the period 20th March 2021 and 31st March 2021. Nothing more, nothing less. So what has expired is something which was expiring, something which was barred by limitation. Only those actions, they got an extended life by virtue of TOLA. Admittedly, 1516 limitation was not expiring. If limitation was not expiring, the question of thereafter extending the limitation would not arise. And therefore, Supreme Court's entire argument is that, sir, TOLA has extended the limitation from 1st April to 30th June 2021 for all the actions which were getting expired in that period. Now, here, 1516, nothing was expired. Therefore, TOLA has admittedly no application for 1516. If TOLA has no application for 1516, probably the only argument is that, sir, 1516 was part of Ashish Agarwal. Supreme Court in Ashish Agarwal has sent all the matters back to the file of the assessing officer. And because that setting aside took place by Ashish Agarwal, the revenue will get an additional inning, and therefore 1516 would stay alive the moment it has a tax impact of more than 50 lakhs of rupees. Because less than 50 lakhs in any case, it will be barred by limitation. More than 50 lakhs, again, because Ashish Agarwal has revived it. Therefore, however, if you read paragraph 108 of the Supreme Court judgment in Rajiv Bansil, wherein they have analyzed Ashish Agarwal vis-a-vis TOLA, all they have said is that Ashish Agarwal was conscious of TOLA, and therefore, wherever the matter was expiring, only thing which was done by Ashish Agarwal was to revive the limitation, which was otherwise extended by TOLA. Supreme Court has not extended any limitation for any year. And if we look at it from that angle, that what is it that was expiring? Because the sum and substance of Supreme Court judgment is that we can't read first proviso of New Act 149 without giving reference to TOLA, and therefore whatever was expiring got extended by TOLA, and therefore to that extent revenue was justified in issuing the notices within that extended period. Now, if I remove the application of TOLA from this equation, then there was no reason for revenue authorities to have issued notices for 1516 under the old regime. They certainly could not have issued the notices for 15-16 under the old regime on the ground that we got an extension. Extension admittedly was not applicable. Therefore, there was no enabling provision. Neither TOLA nor notifications empowered the department to issue any notices for 15-16 within the first quarter of that financial year 2021. If there was no empowering provision, then the notices are admittedly bad in law because those notices were issued under the old act, whereas new act has already come in play. Ashish Agarwal is now explained to the effect that all that Ashish did was to extend the time limit which was flowing from TOLA. Now here there was no extension of time limit which was flowing from TOLA, and read with the concession, and rightly so. Revenue has rightly given the concession because they realized that all these 15-16 notices are hopelessly bad because there is no question of TOLA. And therefore, the concession has to be read in its true spirit and substance. And therefore, Supreme Court also accepted that proposition that all the notices for AY 15-16 issued between 1st April and 30th June 2021 has to go at whatever stage that they are pending, they have to go. That would take me to the last interesting part once again of this judgment, namely the assessment years 16-17 and 17-18. 16-17, 17-18, the controversy was different. Look, 16-17, 17-18, 6 years were not getting over. Therefore, that was not the controversy. The short controversy was that the sanction, which is flowing from the reading of the Act, under Section 151 of the Act, is required to be obtained from which authority? That was the short issue which was there before the Honorable the Supreme Court. All of us are aware that sanction under 151 is once again a kind of check and balance which is there in the statute book. Courts have taken a view that wherever the sanction is contemplated, you have to obtain the sanction. If you do not obtain the sanction which is contemplated by the designated authority, then your entire reopening action is without jurisdiction, without authority of law. And therefore, the sanction aspect is discussed by the Supreme Court in paragraph 73 onwards. They have discussed that under the old regime, there were two sanctioning authority up to a period of 4 years, lower authority, beyond a period of 4 years, up to 6 years, higher authority. Likewise, under the new regime after 1st April 2021, again 151, small Roman 1, up to a period of 3 years, the lower authority, beyond a period of 3 years, up to 6 years, higher authority. Therefore, the short question was that whether the extension is also given to the sanction or there is no extension to the sanction. Because once you look at the provisions of sanction under 151, one would realize that there is no limitation which is there. This is very important. Kindly remember this because unlike 149, unlike 148, where there are different categories, where there are different limitations, under 151, there is no limitation. All that is required to be done is in which pigeon box you would fall. Below 3 years, above 3 years, under the new scheme, within 4 years, beyond 4 years, under the old scheme. So the only thing which was to be decided was under which category I would fall. There was no question of any outer limitation. There was no question of any time getting expired. And therefore, there is no question of any extension as well. Supreme Court was conscious of this fact. And therefore, Supreme Court has noted and only they have given comments only in respect of within 3 years and beyond 3 years in paragraph 77 and 78. Other than that, they have not touched upon the aspect as regards something is getting expired or something is getting barred by limitation. Those aspects are not touched by the Supreme Court. Therefore, what is it that is held by the Supreme Court in Rajiv Bansil as regards 151? Supreme Court said that yes, under 151, also revenue authorities will get an extension. And therefore, for 17-18, the example which they have given is that for 17-18, if the limitation is expiring on 31st March 2021 for a period of 3 years, that will get extended to 30th June 2021. Now that extension is granted. Supreme Court has stopped there. that the extension vis-a-vis only 3 years, we will hold that up to 30th June 2021, if the sanction is granted, then it will be treated as if it is granted within a period of 3 years. And therefore, to that extent, extension is granted. However, the problem will arise because in almost all these matters, the sanction is at a much later stage. Extension was up to 30th June 2021. Sanctions were obtained sometime in 2022. Supreme Court has noted that there are 4 sanctions which are contemplated under the new act. Sanction at the stage of preliminary inquiry under clause small a, at the issuance of show cause notice stage, clause B, at passing of the final order under clause D, and issuance of notice under 148 per se. The first 2 sanctions, namely A and B, extension is already granted by Ashish Agarwal. Ashish Agarwal has already done away with these 2 sanctions. They said that because we are deciding the issue post facto, we will presume that these sanctions are already obtained, and if they are not obtained, then we are setting it right under Article 142. Therefore, small a, small b sanctions are now outside the picture. Supreme Court has noted that nonetheless, the 2 sanctions, namely clause D sanction and final 148 notice sanction, still survive, and they are required to be obtained, without which the entire reopening notice would fail. Now, these 2 notices, these 2 sanctions at clause D order and 148 issuance stage can only be obtained once clause D order is passed, because sanction, for the purpose of sanctioning authority, they need to have the order in front of them unless they can sanction it. So those sanctions took place sometime in the later half of July 2022 when clause D order was passed, or sometime in the first week of August when clause D order was passed. So broadly, in July and August 2022, the sanctions were obtained. Now, that extension which was running up to 30th June 2021 cannot go up to July 2022 because there is no such finding by the Supreme Court, and therefore we have to read the judgment as it is, that the extension was granted up to 30th June 2021 and it rested there. Therefore, in July 22 or August 22, when the sanctions were obtained for these 2 years, 16-17 and 17-18, admittedly, they were obtained beyond a period of 3 years from the end of the relevant assessment year. Therefore, the sanction has to be necessarily of a higher authority. And this is precisely what the high courts have decided, that when you obtain a sanction which is beyond a period of 3 years, then you have to obtain the sanction of a higher authorities. In all these cases of 16-17 and 17-18, the sanction which is obtained is that of a lower authority, which is contemplated for up to a period of 3 years. One offshoot of this is probably revenue might argue that reading at paragraph 94, once again, even for the purpose of 151, we have to exclude the period which is given in paragraph 94, that up to 30th June by virtue of TOLA, from 1st July to 3rd May by virtue of Ashish Agarwal, and from 4th May up to the response by virtue of 3rd proviso to 149. Therefore, even our sanctions would sail the same boat. However, my view is slightly different. My view is that this extension cannot be given to 151 because there is no limitation which is getting expired, and therefore nothing can be extended. Exclusion from the limitation is not going in sync with the TOLA Act itself, because TOLA talks about levy of interest, etc. for belated compliance. However, more interestingly, the 3rd proviso which is relied upon by the Supreme Court for the purpose of extending time for 148 is not applicable in so far as 151 is concerned, for the simple reason that the enabling amendment came at a later stage. Let me share that section for you to appreciate. Kindly look at the proviso to 151, provided that the period of 3 years for the purpose of clause 1 shall be computed after taking into account the period of limitation as excluded by the third, fourth, fifth, or extended by the sixth proviso to subsection 1 of 149. Therefore, the amendment came with effect from 1/4/2023. This was applicable nonetheless to notices which were to be issued under 148, read with 149. However, for the purpose of sanction, this exclusion is now taking place at a much later date, that is 1st April 2023. And therefore, while in 2022, this 151 exclusion read with the third and fourth proviso itself was not there in the statute book. And therefore, the authorities cannot invoke. And therefore, here, insofar as 151 is concerned for 16, 17, 17, 18, the limitation would expire much earlier, because that period for filing the response, etc., which is not to be counted for limitation purposes for issuance of notice, is to be counted for the purpose of 151. And therefore, it will certainly go beyond a period of 3 years. Once it goes beyond a period of 3 years, then admittedly, you need a sanction of the higher authority. Therefore, all the matters 16, 17 and 17, 18, Supreme Court has agreed with the finding of the High Court that yes, we can only give an extension only up to 30th June 2021. Any notice which is issued beyond 30th June 2021, namely in 2022, with a sanction of the lower authority has to be necessarily caused, because that is not a proper sanction in the eye of law. Two side issues before I conclude. One side issue is what is the effect of proviso to 149, because proviso to 149 is Supreme Court has now very categorically and beautifully explained the proviso to 149 to the effect that whenever an assessment year is time barred under the old regime, you cannot issue the notice under the new regime. In other words, supposing if the notice for reopening for assessment year 17-18 is issued after TOLA controversy on after 31st March 2024, namely on the, let's say on 30th of June 2024, for 17-18 on the ground that now we have a larger limitation period of 10 years, or it is also falling within a period of beyond a period of 6 years, but within a period of 10 years. Therefore, 17-18 we can open right up to 10 years. Supreme Court has said that that cannot be done, because that 17-18 would have, the time limit would have been over by 31st March 2024 under the old regime, and therefore you can't thereafter extend the time by reading the first proviso. That ratio is already applied by Delhi High Court in some other judgment of Felix generics, etc., and has already been appreciated. But Supreme Court in categorical terms said that if the limitation is over under the old act, you can't apply the extended limitation under the new act, and that exercise of applying the limitation has to be done on the day on which notice is sought to be issued. And therefore, every time the notice is received, you have to apply the old provision and find out whether limitation is over or would have been over under the old provision or not. Second interesting issue, which is Supreme Court has categorically stated at many places that post Ashish Agarwal, if material is not given, then that is not due compliance of Ashish Agarwal. I think don't fall for that calling for the material argument, because the moment you raise that material argument, that sir, I have not received the necessary material, in the very next paragraph, Supreme Court said that the limitation would start running only after the material is supplied. Therefore, it's a double-edged sword. If you want material, then your limitation would get extended. And my advice is that don't go after the material, because in any case, material, whatever was available is already given to you. And therefore, the moment you raise an argument that, sir, I have not been given the material as per Ashish Agarwal, and therefore my reopening is bad in law, they'll say that all right, now we will supply the material. However, Supreme Court said that up to the stage to which material is given, that period is required to be excluded. Therefore, by getting material, you will be falling within the limitation period, and that would probably create a problem for you. So to summarize my personal view, that the issue is kept alive. On one hand, government talks about reducing the litigation by introducing the schemes like VSV. Again, VSV yesterday, day before yesterday, we saw the clarifications, and the tenor is that they don't want to have larger participation, because large number of issues where VSV could have been filed, all those issues are kept aside. They are kept outside the purview of VSV. Therefore, scheme is there. However, the desire to settle the litigation is not there. That said, that they want to reduce the litigation, department is fighting tooth and nail to the effect that we want to reopen all these cases. If they want certainty, if they are increasing the limit for approaching various courts so as to reduce the litigation, then why such an impractical view on the issues which have already attained finality before various courts? Now, once again, Supreme Court has decided something which has opened a Pandora's box. I'm sure that almost 50% of the cases of 13, 14, 14, 15 would go under the limitation, under the alternate argument accepted by the Supreme Court. All the cases of 16, 17, 17, 18, 151 argument again is going to be decided. And I'm sure that revenue is going to challenge that. And once again, we'll have a third round of litigation, which could have been avoided. And this is the reason why the courts are clogged with large number of matters. If a view is taken that, sir, we want to attain finality, those who have already been subjected to such a litigation, we want to buy peace of mind, and we want to have a new inning at the future assessment rather than looking backward and reopening the past assessments. My personal belief is that revenue once again has created large number of pendency for itself. And in a days to come, they may come out with a few more VSVs to reduce this 90,000 plus pendency before various courts. That's all.